Be seated. The court is now in session. Today, the Chamber will continue to hold a proceeding to hear observations and remarks by parties as a consequence of the decision by the Supreme Court Chamber regarding the immediate appeal by the co-prosecutors against the severance order regarding the scope of case 002/01. We have so far held 2 days of hearing regarding this very matter, but we have yet to conclude it. And today we will continue to hold it for this morning session, so that hopefully the Chamber will have all the grounds, and then we will be able in a position to make a decision and to expedite the proceedings in case 002/01. We will first hear the responses by parties to supplementary questions put forward by the trial chamber in our memorandum on the 18th February 2013, where we issued it on the 19th February 2013, document E264. We may have additional questions to the parties if deemed required. In order to expedite today's proceeding, and as we already reminded all parties yesterday, please look at the main points in all those questions in our memorandum carefully, and please respond directly to those questions in our document E264. And we make a slight change to the process of the proceeding. So all parties are instructed to respond in full for all the questions raised in the memorandum, not one by one, but all in one time. And after one party concludes their response, then another party will be given the opportunity to reply or to respond. We are of the view that time allocation is necessary. The co-prosecutors would have 40 minutes. The lead co-lawyers may add to what would be presented by the co-prosecutors, so they would have 20 minutes. And each defense team will have 20 minutes. As for the response time to the last questions for the co-prosecutors and the lead co-lawyers, we will see if there is needed, and the time will be allocated accordingly. Mr. Evidentiary, could you report the attendance of the parties and individuals to today's proceeding? Evidentiary, Mr. President, for today's proceeding, all parties to this case are present, except the accused Insari, who is present in the holding cell downstairs due to his health concern, and another accused, Noon Chia, is absent due to his health reason and is being treated and being arrested at the detention facility. However, through his counsel, Nuon Chea informs the chamber, although he is not present in today's proceeding, he does not object to the proceeding. Thank you. President, thank you. Based on the information we received on the 18th February 2013 proceeding regarding the severance of the case, we observed some challenging issues. As a result, we request further information from parties as follows. We request that the co-prosecutors to provide the relevant paragraph they deem necessary to add to the extension of the scope in this case, where they submit their proposal besides the forced movement phase 1 and 2 and the killing at Tulpu Chey. In document E163 dated 27 January 2013, the co-prosecutors indicated that paragraph 192 to 204 and the relevant paragraph 575 of the closing order in case 002 shall be included in case 002/01 so that S21 can be included. Based on the scheduling of the trial chamber, certain additional paragraphs should be added in order to render coherent these proposed extensions, in particular paragraphs 949 to 974, in addition to paragraphs 178 to 191, 207 to 209, 916 to 936, and paragraph 975 to 977. At the August 2012 trial management meeting, the co-prosecutors appeared to agree that these additional paragraphs would also need to be added, even though the addition of further paragraph may have an additional consequential impact on witnesses to be heard and documents relevant to the trial. Further, and should the co-prosecutors seek to add grave breaches charges in consequence of a proposed extension to S21, as was suggested on the 18th February 2013, further paragraphs in the indictment, namely paragraphs 150 to 155, paragraph 1480 to 1488, 1491 to 1492, 1498 to 1510, and paragraphs 1515 to 1520 would need to be added, and additional evidence possibly adduced, specifically in relation to armed conflict and its international character. For that reason, the trial chamber requests the co-prosecutors to consider this information and provide a definitive list of all indictment paragraphs proposed for inclusion. And in consequence of the SCC decision, the Chamber has already received numerous requests from the parties for the adjournment of proceedings or relaxation of other trial deadlines. All parties are invited to comment on the below proposed trial schedule for the following weeks and the timing of the decision on severance in light of the following considerations. 1. The health of the accused has been considered by the trial chamber and endorsed by the Supreme Court chamber as a determining factor for any decision on the scope of the trial. Medical experts are scheduled to be heard by the chamber in mid-March 2013, and their expertise may affect the determination of the scope of proceedings. 2. A written decision on severance with extensive reasoning as mandated by the Supreme Court chamber will very likely not be available in true official ECCC languages for another 2 to 3 weeks. 3. The testimony of expert Philip Short has been scheduled for next week, and Elizabeth Becker tentatively for the week after. Philip Short's availability is very limited, as is Elizabeth Becker's, who has already been postponed twice. If these experts are not heard as currently scheduled, it is likely that the chamber will lose the ability to hear them at all. Should witnesses scheduled to testify prior to a written severance decision be postponed, or alternatively, could they testify at least in relation to the scope of trial as understood by all parties prior to the enactment of the severance order and related decisions? The Chamber requests parties to comment in relation to the following individuals whose testimony is scheduled imminently, namely Philip Short, Elizabeth Becker, TCW 724, TCW 794, TCW 100, and TCW 110. And in order to obtain the most accurate assessment possible for the likely prolongation of proceedings that would stem from the grant of the co-prosecutor's request to include S21, the parties are requested to address the following issues. 1. The co-prosecutors have calculated the time necessary to extend the scope of trial through S21 to require no more than the hearing or rehearing of 5 individuals, namely Kang Gek Yew, TCCP 21, TCW 540, TCW 698, and TCW 232, entailing an additional 11 trial days. They also seek to put forward approximately 200 documents which would likely require an additional document hearing. The co-prosecutors are requested to confirm these projections and, in addition, clarify whether or not the co-prosecutors seek to include S24 pre-SAW within this proposed extension. 2. The premise that the proposed extension could be accomplished following only a limited number of hearing days depends on the ability of the accused to participate in trial or their readiness to waive their rights to be present. The Chamber notes that for the better part of the last 2 months, one or more of the accused have been hospitalized. The trial was able to continue only because the accused waived their rights to be present in relation to the hearing of a limited number of individuals. Could the defense teams indicate whether their client's willingness to waive their rights to be present would continue in the event the accused were unable to attend proceedings, and the above individuals relevant to S21 were called? That is, the 5 individuals. The last point, that is number 3. Could the co-prosecutors clarify whether the estimates of time required for the conclusion of a new S21 trial segment depends on the admission of transcripts from case 001? In light of the criteria for the introduction of trial transcripts from other trials, in the Trials Chamber's decision, that is document E96/7, the defense teams should address whether or not they would seek to contest the admission into evidence of case 001 transcripts concerning S21, to which the co-prosecutors and the lead co-lawyers may respond. And the co-prosecutors and the lead co-lawyers will be given the opportunity to respond later to this last point. I'd like now to give the floor to the co-prosecutors to respond to all these questions put forward by the trial chamber. You may proceed.
Thank you, Mr. President. Good morning, Your Honors, and good morning to everyone. Let me start with the first question in paragraph 2 of your memo, which asks us to specify the additional paragraphs. As is referenced in your memo, and as we previously advised the trial chamber last year in our filing for the August 2012 trial management meeting, in addition to the core allegations of the closing order on S21, which are paragraphs 415 through 475, the trial chamber should also include, if S21 is added, the following paragraphs. Paragraph 178 through paragraph 204. That's 178 through 204. This is the section of the closing order that sets out the JCE policy relating to security centers, killing of enemies, and purges. In addition, paragraphs 916 through 974 should be included. That's 916 through 974. These are the paragraphs relating to Nuon Chea's participation in security centers and executions, including S21. Similarly, paragraphs 1048 through 1089 would be included. These are paragraphs relating to Ing Sari's participation in security centers and executions, including S21. And similarly for Khieu Samphan, paragraphs 1172 through 1190 should be added. Now, the memorandum that was issued by the trial chamber on Tuesday afternoon that Your Honor just read also asked whether paragraphs 207 through 209 and paragraphs 975 through 977 also needed to be added. The answer to that is no, and the reason is that those paragraphs were already included by the trial chamber in the scope of case 002/01, and I would refer the trial chamber to document E124/7.3, E124/7.3, where you will see that those paragraphs have already been included in the original scope. In regards to the closing order allegations regarding grave breaches and the existence of an armed conflict, we agree that the trial chamber needs to include the one page of allegations regarding the armed conflict that is found at paragraphs 150 through 155, and in addition the relevant paragraphs setting out the legal elements or characteristics of grave breaches offenses, which would be the following. And I note that we have some slight minor corrections to the paragraphs that are identified in your memo. The paragraphs we believe need to be included would be 1480 through 1484 and 1487 through 1488. I note here that two paragraphs that were in your memorandum, 1485 and 1486, need not be included as they relate to different crime sites or events, specifically the O Kun Sang Security Center and the issue of military incursions into Vietnam. In addition, the trial chamber should include paragraphs 1491 through 1493. Again, a note here, just a slight correction. The memorandum had proposed 1491 through 92. The allegations regarding S21 would extend through 1493. And in addition, 1498 through 1510 and 1515 through 1520. The Chamber also asks us in this question to comment on whether the addition of these paragraphs would have any significant impact on the witnesses and evidence needed to be heard by the Chamber other than that which is already planned or proposed. And the general answer to this question is no. As I will show you with some examples, the evidence that the trial chamber requires to adjudicate these issues is either already before the court, for example, witness testimony that has already been heard, documents already admitted, or is evidence that will be heard through the remaining witnesses that the parties had proposed or that the trial chamber had already planned to hear as part of case 002/01. And because this is a concern that you have expressed, I want to take a few minutes recognizing, and I recognize the time allocation, so I will probably not go into as much detail here as I had planned. But I want to take you through some of these additional paragraphs to show you why, to demonstrate why they would not require significant new evidence beyond that which has already been heard or is planned to be heard. And I would start here with, as an example, the paragraphs that I mentioned that needed to be added regarding the JCE policy on security centers and execution sites. And if your honors review those paragraphs, you will see that the evidence cited is very familiar. The start of the section is actually a repeat of general allegations that were included in paragraphs 156 to 159, which were already part of the case. And they talk about the general policy citing to evidence such as Doig, to David Chandler, to Revolutionary Flag publications. If you look at paragraph 179, as we proceed through this section, there is a discussion of the Constitution of Democratic Kampuchea, a document that was already part of the proceedings of this court and is admitted. The next paragraph, paragraph 180, states, the CPK used several methods to identify those who had carried out activities against the state, including requiring people to write biographies and attend self-criticism meetings. As this chamber knows, this is an issue that has been addressed extensively in this trial in relation to the existing allegations in case 00201. The following parts of this paragraph describe the general procedures for interrogation and torture and are all based on cites to the testimony of Doig. Going to the section of that is titled Dates and Participation, again, we see the same issue. Paragraph 182 are issues that overlap with the historical background section of this trial and concern the pre-1975 events that we have covered. The cites are to Doig, minutes of general staff meetings, which is an issue I did a presentation on a few weeks ago, and interestingly, the testimony of TCW 110, one of the upcoming witnesses who is referenced in the trial chamber's memo. The next paragraph, 183, the subject of it is the July 1975 meeting at which many RAK members attended. The trial chamber will recall that this was an issue that was covered with both of the last two witnesses, military witnesses who testified, and is a meeting that is memorialized in the August 1975 Revolutionary Flag, which is an admitted document. And then there is a reference to other RAK meetings, which again are the general staff meetings that are in evidence and that I presented to this chamber again a few weeks ago. The next paragraph, 184, concerns standing committee meetings at which these policies were discussed. The standing committee and its meetings is, of course, an issue that was already part of case 002/01, and those documents are all in evidence already. The following paragraph concerns two party circulars from September 1975, already admitted and the subject of testimony and presented in these proceedings. The next paragraph, 186, concerns the March 1976 Central Committee decision regarding the authority for smashing. Once again, this is a document that is admitted. This is a document that has been the subject of testimony by witnesses, including Doig and Chandler. The rest of this paragraph concerns that issue of the various organizations in Democratic Kampuchea and their authority relating to security. This is an issue already covered as part of the authority structure section of Case 00201. Paragraph 187 concerns the People's Representative Assembly meetings that were held in April 1976, another document that is already before the Chamber and an issue that has been the subject of testimony with a number of witnesses. And I could continue on through the remaining paragraphs. For example, paragraph 190 concerns the June 1978 Central Committee document called Guidance that was a revision of their policy on enemies. This is a document that is admitted, and the two witnesses that are cited in this paragraph are both witnesses who have been questioned about this document, Doik and Sao Saroon. I make this presentation so that, as the trial chamber has expressed concern over whether these additional paragraphs will require new evidence. And I could take you through each of the sections. In fact, I had done that for others, but because of the time limits, I will move on to the next, to the armed conflict issue. But if the trial chamber has any question as to whether any doubt about this, I am certainly prepared to go through each of the different groups of paragraphs that would to be added to demonstrate to you that they will not require significant new evidence. And I would just add here very quickly that the reason for this, as I have mentioned, is not because parties have been regularly exceeding the scope of the Case 00201 allegations. It is because these issues are part of matters that were already included, whether they relate to historical background, they relate to the authority structures, communications. And I would just note here quickly for you, as an example, some of the paragraphs that were already part of the closing order that address these issues and are the reason that we have already covered much of this. For example, in the historical background section of the closing order, paragraphs 21 and 23, that incorporated the development of the CPK policy authorizing the use of revolutionary violence to eliminate enemies. In the administrative and communications structure section of the closing order were included allegations regarding the arrests and execution of Central Committee members, that is paragraphs 38, 43, and 50. It included the authority of the Standing Committee to order arrests in paragraph 41. It included the role of S71 in monitoring suspected party members and conducting arrests and transfers to S21. That is in paragraph 53. That section included the issue of reporting to the Standing Committee on Enemies, Traitors, and Internal Security Matters in paragraphs 76 to 77. It included the arrests of cadres called to Phnom Penh for study meetings in paragraphs 87 to 88. And it included the issue of broadcast of Vietnamese POW confessions from S21 in paragraph 112. And similarly, the military structure section of the closing order, which was part of Case 002/01, includes allegations regarding the responsibility of the RAK for, quote, the defense of the CPK rule against perceived enemies and spies within the armed forces, the party, and the country as a whole, end of quote. That is from paragraph 117. It included the responsibility of the party's military committee, including Nuan Chea, for the operation of S21. that is paragraphs 122 to 123. It included reporting to the Center on the Discovery of Internal Enemies in paragraph 137. It included purges of internal enemies that were conducted under the orders of the CPK Center. That is in paragraphs 146 through 149. And also it included the use of S-21 for the interrogation and arrest of alleged traitors in paragraph 145. And I will also just briefly note here, Your Honors, that there are also paragraphs in the sections of the roles of the accused that related to these issues. For example, in the case of Noon Chea, paragraphs 873 to 879 were already part of case 002/01. The title of that section of the closing order is Noon Chea's role in CPK security apparatus. So that is the reason why we submit that S-21 and these issues can be tried without, why it is manageable and why it will not require any substantial new evidence for this chamber to hear. Briefly on the issue of armed conflict. I note that first of all, that the new paragraphs in the closing order are relatively short, but also that these are factual issues, as you can see if you look at the footnotes that are cited in the closing order that are relied upon and proven by documentary evidence. Most of the evidence cited in the closing order on this issue are contemporaneous documents from the DK period that reflect the existence of the armed conflict, such as telegrams and reports reporting to the leaders in Phnom Penh on conflicts with Vietnamese forces. These are documents that have been put before the chamber already in our Annex 4. This issue is also proven by minutes of standing committee meetings and meetings of the general staff where the conflict was discussed amongst the leaders. Documents that we have already put before the trial chamber through our Annex 3. And also cited are government statements of the Democratic Kampuchea government and broadcasts from the government media, documents which have been submitted in Annex 5. So, Your Honor, there is already a large amount of evidence before you on this issue, and I can give you some specific numbers here. There are already a total of 5,037 documents to date that either have E3 numbers and have been admitted or have been put before the chamber and subject to adversarial hearings. Of those documents, 694 documents contain information relevant to the armed conflict, including 130 telegrams and reports sent to the leaders in Phnom Penh, 15 statements issued by the Democratic Kampuchea government, 83 reports from the DK media, and 63 international media reports. All of this are contemporaneous records in evidence which document the existence of the armed conflict in Vietnam. And I would note these same documents prove the accused's knowledge of that conflict because they are reports sent to them and they are meetings in which they participated. And if there are any remaining significant documents relating to the armed conflict, we would also include them with the additional documents that we would submit regarding S-21. And as I indicated, this is something we can do in a short time frame should you issue an order adding S-21. We do not, if you look at the evidence in the closing order, it does not rely heavily on witness testimony. We do not believe the trial chamber would need to hear new witnesses specifically relating to the armed conflict. First, I would note that where the closing order does cite witnesses, they are witnesses, some of whom have already been heard by this court, such as Doik, Son Sekun, and in one case, a witness who has been proposed to be heard as part of S21, TCW 540. And I would also note for the chamber that there are 2 or 3 upcoming military structure witnesses who the chamber has already planned to hear: TCW 110, TCW 253, TCW 398. Each of these 3 military cadres were persons who were assigned to the border conflict with Vietnam in late 1977 or early 1978. So, like with the other paragraphs of the closing order, our position is that the trial of this issue would not require any significant new additional evidence to be heard by the chamber. A couple of just quick logistical points, suggestions, if you will, that I would make that may allow us to save some time on these issues. The trial chamber's practice in the past has been to separately review the footnotes of closing order paragraphs, to review the documents cited and to assign them E3 numbers. It may be possible for you not to do that here. I can tell you that in submitting our document list, the first thing we did was go through the closing order, and we endeavored to include in our document lists every document cited in the closing order. So I'm not sure whether perhaps the trial chamber has a system worked out that allows it to do this quickly, but if not, you can rely on our document lists. We included in our document lists everything cited in the closing order. Therefore, if it is a time-consuming process for you to go through footnote by footnote, you can rely on our submissions of the relevant documents on that issue. The other logistical
The President, as for the time allocated to you, you were given 40 minutes, and now we have to be specific with the time allocated by the chamber, and the chamber envisaged that we could finish hearing the views of all parties this morning. Actually, what the chamber is asking is the specific list concerning specific paragraph that the chamber seek your views, and the prosecutor is expected to indicate to the chamber that these paragraphs are relevant to the request for the expansion of the scope. So please express your view as such to make the issue brief, Mr. Co-Prosecutor. Can you please advise the chamber as to how much time you need to address this issue, because we have a few more questions, and these questions needs to be addressed by the co-prosecutors, and particularly the last question, which is subject to a lot of questions as well, so that the chambers will have the basis for the decision on this issue.
Thank you, Mr. President. I started at 9:25, so I'm endeavoring to finish by my 40 minutes. This first question was the time that I had planned to spend the most time on. The other questions are more easily answered. But because your questioning did not just ask us about the paragraphs to include, it asked us to comment on whether including these paragraphs would require additional evidence. That is a fairly complex question, and we wanted to be absolutely certain that our position was clear and explained as to why we believe that, not just stating our position, but explaining why. So I will move on now to the next question that the Chamber has asked, and that concerns the issue of how to proceed, particularly with witnesses, pending the trial chamber's decision on severance. In regard to the comments of that as to the effect of the medical expert testimony that is to take place, we understand that that may have an effect down the road. However, the experts are likely only to be able to tell us whether the accused are currently fit, whether they are currently fit at this time. It's very unlikely that medical experts can give us any sort of precise time period to tell us they're going to remain fit for another 2 months, 6 months, or 2 years. So, while certainly this is a consideration, it's not something that I think you would need to delay your hearing or delay your decision until. Concerning Philip Short and Elizabeth Becker, first thing, we just want to note that the trial chamber's memorandum indicates that Philip Short is scheduled for next week. Our understanding had been that next week there was a planned recess and that Philip Short was scheduled to arrive on the 4th of March. So we just wanted to clarify with the Chamber whether that remains the case, that Philip Short will start on the 4th of March, or whether his testimony has been moved up to next week, as we are unclear on that. However, on the issue of whether there is any legitimate reason to postpone hearing witnesses pending your decision, our answer is that there is none. To the contrary, to ensure the expeditious completion of this trial, we believe you should resume witness testimony as soon as possible. And specifically, with relation to Philip Short and Elizabeth Becker, the trial chamber has already authorized these experts to be examined on the full scope of case 002. And I would refer you to a memorandum you issued on the 25th of May, 2012, which was regarding 4 experts, David Chandler, Philip Short, Elizabeth Becker, and another expert who has not been scheduled. But the Chamber explicitly states in this memorandum, the Chamber provides advance notice to the parties that it will examine the above proposed experts on all issues on which they are able to testify within the scope of the Case 2 closing order. This is why when David Chandler came to testify, he was examined on the full scope of Case 002, and the trial chamber has already authorized the same for Elizabeth Becker and Philip Short. Because of that, because these are experts who will be examined on the full scope of Case 002, there is no reason whatsoever not to proceed with their testimony as planned. With regard to TCW 724 and TCW 794, we were a little surprised to see that they were included on the list. These were, the Chamber will recall that back in August 2012 at the trial management meeting, parties were invited to propose witnesses on the Phase 1 list who they believe need not be heard. And in document E236, paragraph 2, recorded the results of that proceeding. At the hearing, we suggested both of these witnesses need not be heard. There was no opposition from any of the parties. So for that reason, we were not sure whether the inclusion of these witnesses on this list was an oversight as these people have not been part of the lists of upcoming witnesses that we have been receiving, or whether the trial chamber has made a determination that, notwithstanding our indication that it has reasons it wishes to hear from these two witnesses. But it remains our position that these are two witnesses that we do not believe need to be heard. If they are heard, however, I would note that TCW 724 is a very elderly witness, and he would therefore fall into the category of people that the trial chamber has authorized examination on the full scope of case 002. And with respect to the other two witnesses, it is also our position that the trial chamber should go forward. It seems likely that if the trial chamber issues a decision in 2 to 3 weeks, that these witnesses would probably come after that. However, both, if not, our position would be that the parties should proceed to examine on the full scope of case 002, but within the same time limits that the court already established. No additional time would be needed or granted. And let me turn now to the last group of questions in your memo. First, we are asked to confirm our projections for the time of the proposed S21 witnesses and the number of documents. I do confirm that. I would note that the 200 number represented the S21 prisoner lists and S21 confessions. As I indicated, 600 of those documents have already been admitted, 200 remain. There is another, as I said, there will be some more miscellaneous documents in addition to that. So it will be, the best estimate would be somewhere around 250, no more than that. The question of whether the co-prosecutors seek to add S24, the answer is no, we do not. That is a separate part of the closing order that we do not propose to be included. Question, issue number 2 in your paragraph 4 is the concern about the number of hearing dates given the sickness of the accused. That is obviously a concern to all of us, but it is true for all aspects of this trial. And if the accused, for some reason, were unable to continue to participate in this trial anymore because of their health, the truth is, Your Honors, we will not be able to finish any part of this trial. So we certainly hope that that is not the case. We will be hearing, of course, from experts. I note that the last 2 months is the cold season in Cambodia. It is a time, probably a difficult time, particularly for elderly people. Q Sampan himself, who is a relatively healthy person, was sick. So the bottom line, Your Honors, is that adding S21 does not fundamentally change the scenario. We simply do not know how long the 3 accused will be able to participate. We do know, however, that we must try to make this trial reasonably representative in order to comply with the Supreme Court's decision. The last question is, could the co-prosecutors clarify whether their time estimates depend on the admission of transcripts? The quick answer to that is no. Our time estimates do not depend on what is decided on that issue. And just to use my last few minutes, let me just explain a little bit about this issue. And I go back again to the fact that when this issue was first discussed back in August 2012, the trial chamber expressed its view that no witnesses needed to be heard in court regarding S21 because the court could rely on written records, statements, that were pursuant to its decision on the admission of written statements. Now, we proposed that it was necessary to hear a minimal number of witnesses, and that is why we proposed Doik and the 4 witnesses. But it remains true, as the trial chamber indicated in that document, that the trial chamber will be entitled, pursuant to its decision E96-7, to rely on other witness statements, not for anything related to the acts or conducts of the accused, and we do not propose that, but it is entitled to rely on other witness statements where they are cumulative of issues that are heard from live witnesses in court. So our position remains, as it has been, that any testimony from Case 1 is subject to the same standards, where they are witnesses who have appeared here and testified and been examined by the accused. There is no question about their admissibility. If they have not, then they are subject to that test. They cannot be used for acts and conducts of the accused. They can be used where cumulative of other allegations relating to S-21. So, in simple, the answer to your question is no. Your ruling and your admission of these documents would not affect our position on the witnesses that need to be heard.
President, Judge French, you may proceed.
I just want to make a comment and actually ask the prosecutor if they don't think that this is a relevant factor. It pertains to the medical experts. Obviously, the main question is to provide the foundations for a fitness decision, but I would guess that it's also possible that they are saying, yes, they are fit, but only to sit half a day, only to participate half a day, or only 3 days a week, or whatever. Wouldn't the prosecution agree that under these circumstances, the medical expertise is a relevant factor for any decision of the chamber on severance, because it has might potentially have a grave impact on the question or on the assessment of prolongation or possible prolongation of time?
Well, my response to that would be yes, the experts may say that our recommendation is that they only participate for half days. What I'm saying, Your Honor, is that there is no way those experts are going to be able to tell you whether they would be fit to continue doing that for 6 months, 8 months, or a year, or 2 years. So ultimately, these medical experts cannot tell you that we will not be able to complete these issues. They may give you guidance. They can tell you whether they are there.
There is no translation in Khmer. Could you please check? Court officer, could you coordinate with the interpreters and check if there is any technical issue? President, the co-prosecutor, you may resume. Please make your response once again, as there was no translation of your previous part.
Thank you, Mr. President. My response, Judge Fens, is that yes, it is conceivable that we will learn information from this that could be relevant as to how this trial proceeds, but I would maintain that it's very unlikely that these experts, even if they said that the accused should only sit for half days, they would not be able to tell us whether they can continue doing so for 2 months, 6 months, 8 months, 1 year. So they will not be able to give us the answer as to how much time we have to complete this trial. And it's for that reason that we think that their opinions, while certainly of interest, will not be determinative on this issue.
President, the co-prosecutor, it seems that you haven't given any clearer response to our question, as during the proceeding on the 18th February 2013, the co-prosecutor requested to extend the scope of S21 as well as the grave breaches of the Geneva Convention related to S21 Security Center, and that you require 11 court days. We put the follow-up questions to you regarding the different observations made by the trial chamber and the co-prosecutors as for your request for extension of the scope in case 002/01. And you said that additional paragraphs should be added. As for the additional documents requested, on the 18th February 2013, you said that the documents should be in the total of 200, and now you said it could be up to a maximum of 250 documents. And it is possible that a document hearing might be held on its acceptability to be considered put before the chamber. For that reason, we request your comment on the request to extend the scope of the proceeding, including S21 and the grave breaches of the Geneva Convention in relation to S21, and whether your estimated court days, that is the 11 estimated court days, remain the same, or there could be changes to these proposed court days, as this is also relevant to other parties' responses. Because if at the moment you think that it's going to take only 11 court days, but in reality it's going to take 30 court days, and that's going to have an impact on the scheduling by the trial chamber. Could you please give us your comment on the concrete court days that you required for your request of the extension of the scope? And this is the gist of what we want from you.
Thank you, Mr. President. Let me be clear. The 11 days was the proposed total time for the hearing of the 5 witnesses. The court certainly has its authority to establish time limits, as it has done, and to hold the parties to that. So there is no reason for us to believe it would take longer than that, because the parties respect the time limits set by this court. We would require a hearing relating to the 200 to 250 documents, I note, however, that these are the exact same types of documents that have already been admitted, subject to argument by the parties. So I don't think that this would be a lengthy hearing. It would be at most 1 day, and I would expect even shorter. In terms of other time that would be required, that would depend on whether the trial chamber, whether the defense teams had any legitimate witness proposals that the trial chamber deemed necessary. If they did not, we would complete in a total of 12 days. If you wish to assign 4 days further for defense witnesses, it would be 16 days. But those are matters that are within your determination based on the other parties' requests. In terms of what we are saying is necessary, 11 days of witness hearings, 1 day of document hearings.
President, thank you, co-prosecutor. You may be seated. The floor is now given to the lead co-lawyers for civil parties.
Good morning, Mr. President. Good morning, Your Honours, and everybody present. I'm going to hand the floor to my colleague to answer on questions 3 and 4, and after that I'll take up the baton to answer the other questions. Thank you.
Yes, you may proceed.
If it pleases Your Honours, I will be addressing points 3 and 4 within paragraph 3 of your supplementary memo concerning the scheduling of witnesses in relation to the timing of a full and reasoned order, which Your Honours have anticipated will take around 2 or 3 weeks to issue. Your Honours, the real issue is the scheduling of witnesses in a context where the scope and factual allegations to which the witnesses can address is uncertain. 2 immediate questions arise. The first one is, what, if any, prejudice is caused to any party where witnesses are heard before the scope of the trial is known? And secondly, what is the effect of scheduling witnesses prior to a severance order? One possible effect would be the undesirability, inefficiency, inconvenience, and logistical difficulties presented by the possible need to recall witnesses. On this point, the lives of witnesses, particularly expert witnesses, most of whom reside overseas and who have busy schedules, are greatly inconvenienced every time they are scheduled and then cancelled. The expert witness Elizabeth Becker has not been postponed twice. She has in fact been rescheduled at least 4 times. Philip Short has also been rescheduled several times. It is, of course, extremely important that the expert witnesses are heard. They offer specific and specialised knowledge about a distinct part of Cambodia's history and contribute to the overall fact-finding outcomes which Your Honours are to engage. In response to point 3 of paragraph 3 of your supplementary memo, it would be an extremely disappointing outcome and a real loss if the opportunity to hear the witnesses, the expert witnesses, is lost. In response to paragraph 4 of your memo, point 4 of paragraph 3, the civil parties submit firstly that expert witnesses are to be distinguished from ordinary and factual witnesses. This has relevance to the scope of matters upon which they can be examined. I refer to Your Honour's decision of the 5th of July 2012, it's decision E215, entitled Decision on the Assignment of Experts, in which Your Honours refer to your previous determination that expert witnesses may be questioned on the entirety of Case 2. At paragraph 4 of this decision, Your Honours state, as these individuals, the expert witnesses, were proposed prior to the severance of Case 2 into a number of trials, and to avoid their unnecessary recall, the Chamber had previously determined that they may be questioned on all matters within their knowledge or expertise relevant to the entirety of Case 2 closing order. Your Honours then go on to say that in light of ensuring an expeditious trial, the parties are reminded that their principal focus of the examination should remain on the subject matter of Case 2/1, and questioning on matters beyond this scope should be limited to areas which the parties consider these individuals to be uniquely qualified to answer.
President, lawyer for civil party, please slow down for the proper record.
My apologies, Your Honours. So, in summary, as the prosecution have already stated in their reference to the memo of the 25th of May 2012, and in light of this decision of the 5th of July 2012, all parties were put on notice that they could prepare their examination relating to expert witnesses on all matters relating to the entire of the closing order in Case 2. As the prosecution has already highlighted, this has already been applied in practice to David Chandler, who on the 25th of July 2012 gave evidence regarding the genocide of the Vietnamese. Clearly, this is outside the scope of Case 2/1. It is relevant to the JCE policies, but more so relevant to other parts of the closing order. In light of all parties having known that expert witnesses may be examined on all parts of the closing order, the prejudice caused in our submission in scheduling these witnesses earlier is reduced. However, since the focal areas upon which these experts should be examined remains unknown, there will be some prejudice for all parties, and this is not an ideal situation. For these reasons, the civil parties submit that it would be in the interests of efficient trial management and also in the overall interests of justice for Your Honours to issue an advanced and summary notice of your determination on the issues of severance and scope, and this advance notice should be issued as soon as Your Honours have come to a determination and before any witnesses are scheduled. A full and reasoned decision, as required by the Supreme Court chamber, in 2 or 3 languages, can be issued at a later date when it is available. This solution may not be ideal, but it is, in our submission, the best solution in all the circumstances. This approach will ensure that there is no undue delay between the hearing of witnesses and the delivery of Your Honour's reasoned decision, that no prejudice is caused to parties arising from the uncertainty of the scope of examination, that the examination of expert witnesses will be focused, that no factual or expert witness will need to be recalled, and it is, in our submission, an approach that should also be applied in respect of any character witnesses to whom Your Honours consider could also give factual evidence. If there is to be an increased scope on the factual allegations in the first trial, it would be prudent in our submission for the timeframes allocated to parties for witness examination to be revised. Those are the submissions on behalf of the civil parties on these points.
Very briefly on the other points, Mr. President, of which I think 2 remain. Question 1 of paragraph 4 concerning the famous 11 days proposed by the prosecution. I do understand your chamber's concerns in feeling that 11 days might be rather short, and it's probably better to talk about that now, once the famous 11 days, rather than once the 11 days begin, so as not to misuse those days when they do come up. to the detriment of the interests of the civil parties and others. So the prosecution said they require 11 days to hear the people they are proposing, and then an extra day for the documents. We have no problem with that. I also heard that the prosecutor is proposing an additional day for defense documents, and since this wasn't brought up, I will refer to the documents and individuals that might be proposed by the civil parties. I believe that it is perfectly reasonable, and out of respect for the civil parties and taking account of what they can bring to the debate in factual terms, I think it would be very useful for us to hear some civil parties. When I say some, I mean very few, 2, perhaps 3. But I don't think it would be fair or acceptable or useful, if we're going to talk about S21, not to consider 2 or 3 additional civil parties in addition to those that have been suggested by the prosecution. So I would urge the court to give due and reasonable consideration to the fact that the civil parties wish to propose witnesses for S21. We are able to do so at short notice. The number, as I said, will be very limited, but I think it would, at a minimum, need 3 additional hearing days. I do not believe that I am exaggerating or going beyond that to which I am entitled, so I am asking for this in the interests of the trial and in the interests of the parties that we defend. That, sir, is my view on point number 1. On number 2, that's not really our business. It's up to the defense to answer that one. And on response, Roman 3 under paragraph 4, your chamber has given us a detailed answer in decision E97/7 on the transcripts, and so as far as we are concerned, that chamber decision simply should be enforced, and I would rather wait to hear the defense teams taking their positions and for us to then be able to answer them. I think that is planned for in your memo, and I would imagine that the prosecution will be interested in responding to the positions of the defense as well. So on that subject, I won't say anything at this juncture, but ask for the right to do so at a later stage. Thank you.
President, thank you. The time is now appropriate for a short break. We will take 20 minutes break and return at a 11:15. The court is now adjourned.